Welcome to the light. Today we are shedding light on the most recent update in the case of Brianna Aguilera out of Texas. Now, a couple of weeks ago, there was a press conference from Tony Busby, the family, and the Gomez law firm that is partnering with them, where they discussed about filing a formal lawsuit against Austin Black's Rugby and the UT Latin Economics and Business Association. Now, if you want, you can go on my file and watch that press conference. That's going to give you the update there. What I do have is the plaintiff's petition for this case. So it's only 8 pages long. We're going to read through it and get the information that's in here, see what they have. These always give so much more context to the conversation and just information that we may not have known before, which is why I do like reading these. I read 126 pages of the Koberger lawsuit last week, so 8 pages should be a breeze for us today. Let's get straight into it. This lawsuit has been filed in Travis County, Texas, and it is demanding a jury trial. This is the plaintiff's original petition. To the Honorable District Judge of this court comes now Stephanie Rodriguez and Manuel Aguilera, individually on behalf of the estate of Brianna Aguilera, so they are the plaintiffs, complaining of defendants, Austin Black's Rugby Club and the UT Latin Economics and Business Association. They're the defendants in this case, and for cause of action would respectfully show the court the following. Discovery level. Discovery is intended to be conducted under Level 3, pursuant to Rule 190 of the Texas Civil Procedures. Number 2 is the parties. The parties involved, as I just mentioned, Plaintiff Stephanie Rodriguez, Plaintiff Manuel Aguilera. They are the mother and father of the deceased. The defendant, being the Austin Black's Rugby Club, is a domestic, nonprofit corporation doing business in Travis County, Texas. It may be served by and through its registered agent, civil and environmental consultants located, and it gives an address in Austin, Texas. The other defendant is the UT Latin Economics and Business Association, which is a domestic nonprofit corporation doing business in the state of Texas. It may be served by and through its corporate officers. Jurisdiction and venue. This court has jurisdiction over this matter because the damages in question exceed the minimum jurisdiction of this court. The venue is proper in Travis County, Texas, because all or substantially all of the events or omissions giving rise to the claims occurred in Travis County and defendants reside in Travis County. Preservation of evidence. Plaintiffs hereby request and demand that defendants preserve and maintain all evidence pertaining to any claim or defense related to the incident made the basis of this lawsuit or the damages resulting therefrom, including statements, photographs, videotapes, audio tapes, surveillance or security tapes or information, business or medical records, incident reports, tenant files, tailgate contracts, tailgate policies and procedures, TABC documentation, TABC correspondence, periodic reports, receipts of items sold, financial statements, bills, telephone call slips or records, estimates, invoices, checks, measurements, correspondence, email, voicemail, text messages, any evidence involving the incident in question, and any electronic image or information related to the referenced incident or damages. Failure to maintain such items will constitute, quote, spoliation of the evidence. Now, the background. It is illegal to serve minors any amount of alcohol in the state of Texas. It is reckless and irresponsible to grossly overserve a group of minors at a University of Texas football tailgate to the point where those minors lose their physical faculties and ability to control themselves. Sadly, this is exactly what defendants did herein. It has become necessary to bring this suit because of defendants' egregious, illegal overserving of minors, which ultimately led to the death of a 19-year-old college student, Brianna Aguilera, which occurred on or about November 28, 2025. Brianna traveled to Austin, Texas to enjoy the hallmark SEC college football game between University of Texas and Texas A&M held at DKR Stadium in Austin. She and several of her friends traveled to Austin to see one another and spend time together at festivities surrounding the rivalry football game. Brianna planned to attend a tailgate party at defendant Austin Black's Rugby Club's facility near Walnut Creek. The tailgate was hosted by defendant LEBA. Based on present information and belief, Brianna purchased a ticket or was otherwise provided a ticket by an event promoter which assisted in the hosting of the tailgate. According to witnesses, approximately 300 tickets were sold for the tailgate party. The tailgate took place in the parking lot of defendant Austin Black's Rugby Club's facility. This tailgate served alcohol for a large crowd of patrons to enjoy prior to the football game scheduled for that evening. At approximately 6 p.m., Brianna arrived to the tailgate with several friends. According to witnesses, Brianna, amongst many other minors, were served alcoholic beverages by defendant LEBA's tailgate. After a brief period of time, witnesses described Brianna as noticeably intoxicated. Brianna and her minor friends remained at the tailgate for several hours. During this time, defendants continued serving all of them alcohol. As Brianna consumed more alcohol, witnesses described her behavior shifting from upbeat to disoriented and ultimately grossly intoxicated. Brianna began to stumble at the tailgate and lose physical faculties. According to police, she exhibited classic signs of intoxication. Based on present information and belief, witnesses had to assist Brianna with walking and standing at times. Eventually, Brianna stumbled into the woods and lost her phone, all while suffering the incredible effects of too much alcohol for a 19-year-old. After becoming too intoxicated, Brianna, with the assistance of friends, left the tailgate at approximately 10 p.m. Security camera footage at the 21 Rio apartment complex captured Brianna and several of her friends entering the building and taking the elevator to a friend's apartment. Brianna intended to stay the night at the friend's apartment with several other girls. What happened after Brianna entered the apartment is still under investigation, but there is no doubt her intoxication ultimately contributed to her demise around midnight of November 28, 2025. Brianna tragically fell 17 stories to her death. Brianna's senseless death is a direct result of defendants providing a minor with alcohol and over-serving her to the point of extreme intoxication. Plaintiffs bring this lawsuit for all damages available to them under Texas law. Now the next section is the causes of action. So the first claim is negligence, all defendants. Plaintiffs incorporate the previous allegations. Plaintiffs would show that the incident in question and the resulting injuries and damages were brought about and caused by the negligence and carelessness of defendants through the actions of one or more of its agents, servants, and or employees in one or more of the following ways. A. Selling or serving alcoholic beverages to Brianna Aguilera when they knew or reasonably should have known that she was a minor under the age of 21 years old in violation of Texas Alcoholic Beverage Code. B. Selling or serving alcoholic beverages to Brianna Aguilera when they knew or reasonably should have known that she was under the influence of intoxicating alcohol in violation of Texas Alcoholic Beverage Code. C. Failing to provide reasonable education, policies, and or training to employees, agents, and our representatives regarding the serving of alcoholic beverages to patrons, including Brianna Aguilera. D. Providing policies and or training to employees, agents, and or representatives that unreasonably encourage the excess and unsafe serving of alcoholic beverages to patrons, including Brianna Aguilera, and E. Providing and or encouraging policies and or an atmosphere that caused, created, or contributed to a pattern and or practice among employees, agents, and or representatives that unreasonably encourage the excessive and unsafe serving of alcoholic beverages to patrons, including Brianna Aguilera. Defendants owed a duty to hire, supervise, train, or retain competent employees, agents, and contractors. It was apparent to defendants that Brianna Aguilera was a minor and was obviously intoxicated to the extent that she presented a danger to herself and others. Nevertheless, defendants breached its duty to plaintiffs when they continued to provide, sell, and serve Brianna Aguilera alcohol in violation of Texas Alcohol Beverage Code. Further, the character of the accident is such that it would not ordinarily have occurred in the absence of negligence, and that the instrumentality causing the injuries were under the management and control of defendants. B. Gross negligence, all defendants. Plaintiffs incorporate the previous allegations. As set forth above, defendants are responsible for the conduct of its employees, agents, and or representatives, acts and or omissions, because they were done knowingly and with conscious deliberation in spite of the known high degree of risk of harm to others. Said conduct constitutes gross negligence, thereby entitling plaintiffs to punitive damages in an amount to be determined by a jury. Defendants are further responsible for the conduct of their employees, agents, and or representatives because they created the alcoholic serving policies in place at the establishment in question, and because they directly controlled whether the policies of defendants were enforced. Defendants directly controlled managers and servers and trained the managers and servers at the tailgate. Their failure to create, institute, and enforce policies precluding service of alcohol to obviously intoxicated persons and minors was a violation of this statute. Each of these acts and omissions, singularly or in combination with others, constitute gross negligence, which was the proximate cause of this incident and the injuries and damages sustained by the plaintiffs. The next part here is damages. Plaintiffs incorporate the previous allegations. Plaintiff Stephanie Rodriguez is the mother of the deceased Brianna Aguilera and asserts a wrongful death cause of action against defendants to recover all damages to which she may be justly entitled because of the wrongful conduct of defendants, including but not limited to grief, bereavement, torment, and mental anguish. Plaintiff Manuel Aguilera is the father of the deceased Brianna Aguilera and asserts a wrongful death cause of action against defendants to recover all damages to which he may be justly entitled because of the wrongful conduct of defendants, including but not limited to grief, bereavement, torment, and mental anguish. The plaintiff, which is the estate of Brianna Aguilera, asserts a survivor cause of action against the defendants to recover all damages to which the estate may be justly entitled because of the wrongful conduct of defendants, including but not limited to pre-death pain and suffering, disfigurement, and mental anguish. The wrong done by defendants was aggravated by the kind of malice for which the law allows the imposition of exemplary damages. Defendants' conduct, when viewed objectively from defendant's standpoint at the time of the conduct, involved an extreme degree of risk, considering the probability and magnitude of the potential harm to others, and defendants were actually subjectively aware of the risk involved, but nevertheless proceeded with conscious indifference to the rights, safety, or welfare of others. Plaintiffs seek exemplary damages in an amount within the jurisdictional limits of the court. Further, because the acts complained of herein are the result of a violation of the criminal laws of Texas, the punitive damages sought by plaintiffs are not subject to the statutory cap. Now, the next section is the prayer part. Wherefore, plaintiffs pray that defendants answer this petition, that this case be set for trial without delay, and that plaintiffs recover a judgment from defendants for their damages in such amount as the evidence may show and the trier of fact may determine to be proper of at least $1 million, in addition to pre-judgment interest, post-judgment interest, costs, punitive damages, and all other and further relief to which plaintiffs may show themselves justly entitled. The plaintiffs respectfully request a trial by jury, and this was respectfully submitted by the Busby law firm. So that is the full readout of the Brianna Aguilera University of Texas death complaint, where the estate is suing the Austin Blacks Rugby and the UT Latin Economics and Business Association. So let me know your thoughts below on it. I know one of the things they did mention in the press conference that was really important to them of why they brought this case was the fact of discovery and being able to get information from these associations, because the fact that the Austin police were not really investigating or doing their due diligence. So this is kind of like a loophole for them to go with a lawsuit to be able to get more information to investigate Brianna's death. So again, we'll see what happens. And if anything else pops up, I will let you know. Let me know your thoughts below. Thank you for tuning in. Make sure you tap that like button, you share, and you are following me. As always, I will see you in the next one.